You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.
Hello and welcome to the latest Today's Conveyancer podcast. I'm joined by Brian Rogers this week. Brian is the Regulatory Director at Access Legal, probably best known to you as a director at Riliance, which was a risk management tool for lawyers acquired by Access Group in 2019. Thank you very much indeed for joining today, Brian.
Thank you, David.
We're going to be talking about your favourite subject and probably a subject that's close to the heart of many conveyancers, which is anti-money laundering. But first, I wanted to get a little bit about your background. We've heard about the fact that you were involved in Riliance. Tell us a bit about you. What's your work history and experience, and what's kind of brought you into the anti-money laundering space?
Yeah, so had a fairly varied work history. So I actually entered the legal profession in 1992, having served 12 years in the RAF. So I came from a very much sort of regimented, regulated environment. I always liked the law, but actually I didn't want to study it. But what I wanted to do was work in it. So I entered the profession in 1992 as a non-lawyer. One of the first sort of non-lawyers filling a senior executive role. So I worked in all sorts of areas of management and things like that within various law firms. Then in 2006, I was asked to help break away part of a law firm and create a new law firm. So I had to create this new law firm in Manchester and London, take 60 odd people away, completely start up the law firm from scratch. And one of the things that I was responsible for was money laundering at the time, plus all the other risk and compliance areas as well. And so I started looking for a system to try and help me manage risk and compliance without having to have additional budgets to pay for people sitting on chairs and things like that. But there was nothing out there. So, and I knew the regulator, the Solicitors Regulation Authority, was going to be coming along probably in 18 months' time of the business having started. So I thought, well, I need to get all my ducks in a row. And so I spoke with our IT development team, and we'd already developed an in-house HR system. So I thought, well, I'll use a lot of what we learned there to create a risk and compliance system that met all our needs. And that's what we did. So we centralized all our risk and compliance processes. And I purely developed it as an in-house system. But then when the SRA came in, they were due to come in for, I think it was 2 days. Because they liked what we were doing and the way we were doing it, I got them out after 5 hours. And of course, everybody wants to get the regulator away from them as quickly as possible. So I thought after that, there was a market opportunity. So I thought, well, let's go and do all the Dragon's Den bits and all that sort of stuff, and let's see who's interested. The problem was the market wasn't ready at that time. Lawyers didn't seem to have this same enthusiasm for risk and compliance as I did at that particular time. It was very much about looking after the clients and things like that, and that's important. But regulators also want you to look at stuff like that they have. So we formally launched Riliance in 2012, and we sort of had 6 months of really motoring on the sales side, getting people on board. We had about 500 by mid-2012. And of course, the SRA then said that we're going to be looking at bringing in compliance officers for legal practice and finance and administration in 2013. So the Law Society then started thinking, well, how can we help our members? Started looking for a product, came across our product and said, well, why reinvent the wheel? Let's get involved with Riliance. And so the Law Society became a shareholder. Well, the rest is history in effect, because we then built the business up And in 2019, as you say, we were acquired by Access as their first step into creating Access Legal, which was a legal specific division. And since then, the division's gone on from strength to strength. We bought a number of case management systems and other systems as well, so that in effect, law firms can now be completely self-sufficient with one product and one supplier of products. So that's pretty much the sort of the work history. I work very hard looking after clients and sort of being the front face of Access Legal, doing lots of monthly updates, webinars, seminars, all that sort of thing.
And even appearing on podcasts, Brian.
And even appearing on podcasts. Yes, yes.
Tell me a little bit about what you typically get involved in within law firms. We've said that anti-money laundering is a huge issue for conveyancers, and it will only get more challenging. I think most people acknowledge that. What kind of things do you typically get involved in? What do you see when you're in the firm?
AML is a real pain point for firms, as you say, particularly property, because they are seen as high risk. And so what we will be doing is we'll be going in, having a look at people's policies and procedures, making sure that those policies and procedures are actually being implemented, more importantly, enforced and policed, because it's all well and good having documents or, a lot of people now moving away from paper. So whereas you used to put them in the bottom drawer of, of your desk, and they never came out until somebody asked for them. Obviously, there's lots of things on computer now. So whether it's a paper-based document or something which is on your computer, the fact is you need to be reading it on an ongoing basis and making sure people are following it. And this is one of the things that the SRA, the Solicitors Regulation Authority, is very concerned about, and that is the culture. Because, they will go into firms doing thematic reviews, looking at the implementation of anti-money laundering policies and such like. And they will talk to the money laundering officers, they'll talk to the compliance officers, they'll talk to the partners, but they will also then go and talk to people on the ground, because it's all well and good partners saying, oh, yes, we have this policy and we have that policy. But actually, is it being implemented on the ground? What is the culture on the ground? Do we have that sort of communication between the top and the sort of the rest of the firm? And so they're very keen to see that happening. In the past, there's been very much of a sort of a tick box approach. Yes, I'll tick to say I've got this policy and I'll tick to say I've done this training, but actually now prove it. And this is where the SRA is sort of doing a lot of thematic reviews and sort of asking for evidence and things like that. And so, a lot of our work, as I say, is looking at policies and procedures. It's making sure, it's providing the training as well. So this week we've got our quarterly anti-money laundering training course, and we're normally attracting over 1,000 firms to that on a quarterly basis. So training is really, really important, particularly at the moment. We were talking about offline sanctions earlier on. And so making sure that you're up to date with world events and what's going on, what the government's talking about in terms of sanctions and, money laundering, and trying to sort out what money laundering has been going on through London, and, which seems to be a haven for money laundering. It's all important. And one of the reasons it's really important is one of the key documents that you've got to have in place is your firm-wide risk assessment. And again, flowing from that are all your policies and other things. So if you get your firm-wide risk assessment right, you're pretty much going to get the rest of it right. But what you've got to make sure is that your practice or firm-wide risk assessment is up to date. It takes into account world events. It takes into account new guidance and documents issued by the regulators. Where some firms fall foul is that they will review something, but they won't document it. And so as far as the regulator is concerned, if it isn't documented, it didn't happen. And so whether you do something positively or whether you don't do anything at all as a consequence of a review, you need to note the fact that you have done a review and you've concluded that you're not going to do anything as a consequence of that.
On a practical level, how does that work? Where do you need to document it? What kind of note do you need to make?
Well, there are lots of, we provide lots of templates for people. So they can use those. They can use the templates that are published by the Solicitors Regulation Authority. So they have a sort of a template firm-wide risk assessment. One of the biggest issues that the SRA finds when it goes into firms is that people have used templates, but they haven't changed the wording to make them specific to their particular practice. And that is a big problem for the SRA. And certainly I was talking to the SRA recently, and one of the examples they gave was where you've got square brackets and it says insert the name of somebody here. And all they do is they just leave square brackets. So it's just a very much a sort of either a download or a cut and paste, and you don't really review it from there. And so you've got to make sure that whatever templates are available out there, that you actually change them to suit your particular needs. And if the SRA doesn't see that, then they're not going to be happy to start with.
And how does the firm differentiate between the risk checks it makes when it comes to conveyancing, for example, as opposed to private client, perhaps to company commercial? The firm-wide risk assessment has to take account of all of those different disciplines.
Absolutely. And that is one of the key areas that you've got to note down. You've got to know, well, who are our clients? Where do they come from? What areas of work do they deal with? And of course, as everybody will know, property is seen as one of the biggest risk areas going. And again, you look down in London and you've got all these sort of oligarchs buying all these big properties and things like this. The funding behind those is very questionable. And so, you have to go through your firm-wide risk assessment. You look at your areas of work and say, right, well, where are we exposed here? And so where are we exposed? We're exposed here, fine. So how do we mitigate that particular risk? What systems and processes do we need to put in place to look at those sorts of things? So, for example, if we identify that we're in a rural area, we're dealing with Mr. and Mrs. Jones, and we've known them for years and years and years, well, they're not going to be very high risk, I would suggest. But if you've then got people who perhaps come in from elsewhere, and so this is one of the issues that we're potentially seeing with oligarchs not being able to do certain things in London, so they're going out to the sort of the other parts of the country. And some of those firms will look at it and say, well, that's great, we're going to get some really good fees on this. Well, yeah, that's the short-term view. You'll get some nice fees, but actually, are you going to get caught later on? Because these people see that you're not as good at anti-money laundering processes as somebody else. So, you've got to be really, really aware of what's going on in the world, who could be coming to take advantage of your lax regime.
You talked about culture being a really important part of embedding anti-money laundering procedure in a firm. What else have you seen work in practice really embed what conveyancers need to know about anti-money laundering?
Well, training is a big thing. And so making sure that you are updating people as things go on. When I was in practice, yes, you used to have the sort of the annual or 2 yearly training. But actually, what I used to do was when I was seeing something going on through the legal press or the national press, I would be sending emails out to everybody to say, right, okay, you need to be aware of these particular things. So it's ongoing engagement. And of course, with COVID lockdowns and things like that, we've got people working from home. So what are we doing to actually change the way we communicate with people? What are we doing to ensure that people are appropriately supervised and that the culture that we want within the firm is where it needs to be? What security have we got in place to make sure our IT systems aren't being misused and sort of cyber attacks and all that sort of thing? Yes, there was a lot of dread when the lockdowns came into place. Everybody thought the property market was going to collapse again. Fortunately, that didn't happen. But of course, it came with a lot of risks because we then had the stamp duty holiday, and that started really putting pressure on people to turn things over very, very quickly. And when you have that sort of thing, people can then, again, become very sort of blasé about, well, I need to get X number of fees in to meet targets and things like that. And so they will forget what they need to do. And we've seen that in practice where people are not completing their matter assessments. They're not completing their client assessments, or they're completing them in part. You know, I've seen some where a partner has had this document put in front of them to say, can I act for this particular person? The partner's actually signed it, and then when we've done our file reviews, we've then said, well, hang on a minute, they haven't put in here the risk level for this particular client or this particular transaction. And then when you ask the partner, you know, well, why did you sign this without having that on there? They say, well, I'm too busy. So you can see where the cultural issues, you know, if the people at the top aren't going to get the culture right, how can they expect everybody else to? And of course, you know, there's the liabilities. At the end of the day, yes, you have compliance officers for legal practice and all that sort of stuff. You have your money laundering officers for, you know, reporting and compliance. But ultimately, every partner within a practice is joint and severally liable. And, you know, so you've got to make sure that you don't just think, well, it's nothing to do with me, Gov. I'm not one of these, you know, these officers, and therefore I don't need to worry about it. Yes, you do, because you're a partner. You know, whether you're a salaried partner, equity partner, whatever it might be, you know, you are responsible for making sure these things happen. And so those managers keeping an eye on what's going on within the market, property market, as you say, is really, really important, and making sure that all the supervision, management, and everything else that goes with it is right.
You've no doubt got some horror stories knocking around, Brian. What have you seen that really made the hairs on the back of your neck stand on end?
Well, going back to the templates, people basically just getting a firm-wide risk assessment template and not doing anything with it, and then expecting the SRA just to, you know, turn around and say, yep, that's fine because you've got one. No, get away from the tick box. So the tick box mentality is a real problem. Policing and enforcing policies and procedures is another one. Poor client due diligence, and we've recently seen a major firm down in London get a fine of £232,500. You know, the biggest fine going for that sort of thing, and that was as a consequence of, you know, poor client due diligence, allowing your client account to be used as a banking facility. I mean, that's a complete no-no, and I just can't understand why, in this day and age, with all the warnings that there are out there, why people do that. Not having the evidence on file, you know, again, the client due diligence is one of the issues that was found with that particular firm was that the evidence so they were doing client due diligence, they weren't getting the evidence and putting it on the file to show that what they'd actually done, and so, you know, they're the sorts of issues, and it's really sad that you go into firms, and they may be firms that you've actually helped in the past or are still helping, and you've put all these processes in place, but after a period of time, you know, they tend to sort of let it go because they think, well, you know, they're not coming back for 12 months, or, you know, if it's a Lexel firm, and we see this with Lexel firms and other firms with accreditations like the Conveyancing Quality Scheme and things like this, where it's sort of, you know, the standards go up to get the standard, and sort of, and then it sort of drops, and then an assessor's coming in, so it goes back up again, and then we get a letter from the SRA to say we're coming in to do a thematic review, so the standards go back up again. Whereas actually what should happen, and this is where we try to work with firms, is you bring the standards up and you maintain them, because, you know, we're asking questions, we're pushing training, we're pushing all these various things. But so it's sad sometimes to see that sort of thing, people taking their foot off the accelerator.
If we thought that COVID and the impact of lockdowns and the fact that we weren't seeing our clients was going to present a challenge for anti-money laundering, the start of 2022, we thought maybe we're coming out of the challenges therein, and then suddenly we're hit by the Russian invasion of Ukraine, and there's a podcast that we've done on Russian sanctions and the impact on conveyancers. We're never quite sure what the next curveball in anti-money laundering is going to be, but get your crystal ball out. What do you see as the biggest challenges being in the coming years?
Well, certainly from the property side of things, because people are talking about how can we make the conveyancing process more effective, more efficient and quicker and things like that. What we're seeing at the moment, and I think it's going to make the problem worse going forward, is a lot of estate agents and developers putting a lot of pressure on law firms to actually allow the due diligence that's carried out by estate agents in particular to be carried over into law firms. And there's a particular piece of the money laundering legislation that allows for firms to actually rely on third parties to do due diligence. The problem is that has to be in writing, so you have to have a formal agreement. Both parties have to agree to it. So in essence, if you had the right people doing the right things and everything else, then yeah, you'd be quite happy to use that reliance, as the legislation calls it. The problem is that when you look at estate agents, they do not have the best history in terms of anti-money laundering compliance themselves, and the regulators have shown that. And of course, you've then got law firms who are trying to continue getting business from estate agents. And so when an estate agent says, don't ask my clients for more due diligence because we've done it, firms are being in effect forced into accepting the due diligence of estate agents. And my recommendation there going forward is do not be put into a pressurized position. So the estate agent shouldn't be doing that in the first place. The firms should maintain their independence and make sure that they're not being put under that sort of pressure. They also need to recognize that even if they do bow to that pressure, or they do find an estate agent that is good at it and is doing the right things, that ultimately the law firm remains liable for any errors or omissions that are caused by that particular person that they've outsourced it to or relied on. The reason I raise the difference between reliance and outsourcing is that, of course, you can outsource things, so you do your online CDD. That is not reliance under the terms of the legislation. So people need to just recognise that, because I've had a few questions on that one. So there's that as a problem I can see coming up. We've got client due diligence being left to the last minute. So people will leave their due diligence until exchange. It's far too late. And you only need to look at Conveyancing Go Rogue on Facebook, and that came as a consequence of the Simplify group. And you look at all the issues that are coming out as a consequence of that. And to be fair, it's not all about the Simplify group. That's what sort of initiated it. But what's coming out is that across the piece, there's a lot of conveyancers who are not doing things right. They're leaving things too late, and it's holding up transactions. So that is going to be a challenge going forward. I mentioned online CDD, client due diligence, and one of the key things that came out in the legislation when it was last updated was you can use these systems, but you need to understand what you're asking for, and you need to understand what the system is going to generate for you, and to interpret that information when you get it. So a lot of people will sort of get a report and they'll see a nice green tick at the top, and they won't look any further. Well, what they should be doing, and again, this is a regulatory requirement, they should be looking through the report, because although they may have an overriding green, there may be minor reds somewhere in that report. And so they need to understand the technology that they're using. I think technology is great. I think if you can call it a positive out of COVID, one of them is that the legal profession has jumped probably 10 years ahead from where it was going to be. And so adopting technology is very, very important. It has to be the right technology. People have to understand, what they're spending their money on in terms of that new technology, and make sure it works. You can't just sort of think, well, I'll go and buy this product and then get somebody to implement it, but actually not fully understand and utilize it completely. I think one of the other issues is that we've got going forward is the cost of due diligence. How do we, fortunately, the Solicitors Regulation Authority about 12, 18 months ago clarified the position in relation to being able to charge for anti-money laundering checks and things like this. And so as long as firms charge a reasonable price and they don't add secret profits to it, so, if the check is going to be £12, say, then, you show the client a charge of £12. If you then want to put an admin cost on it, well, fine, you put that separately. And you don't show it as a disbursement. A lot of people have sort of thought, well, it's a disbursement. No, it isn't. It's part of your overheads. It's part of your checking. So yes, you can charge for it, but you've got to be careful where you actually put it. So I think, there's quite a few challenges that firms are facing at the moment, and they'll continue to face those. And I don't like being a doom monger and things like this, but when you read the papers and you listen to what people are telling you, we're seeing property values going through the roof at the moment, and demand outstripping supply and things like this. And I think there is a view at the moment that we're heading for another crash. Now, whether that will be a big crash, small crash, who knows? I hope it doesn't come, but there are indicators there that show us that could potentially happen. And so I think one of the biggest takeaways that I would say to firms on the challenges is learn the lessons from the crash, the 2008 crash. Don't put all your eggs in one basket. Plan ahead. What happens if we do take a 10, 20, 30% hit on our conveyancing? How are we going to fill that void? How are we going to adjust things? One of the things that we found in the 2008 crash was that because the conveyancing market had gone and people were trying to avoid redundancies, they were putting people into other areas of law, but they weren't providing them with the training to do that. And so that's when we then have professional indemnity insurers who then say, you're playing at it. We're going to put premiums through the roof because people are playing at conveyancing. They're not doing the right things. And I think, we do have to remember professional indemnity insurers, they are the kingpins at the moment. The market is so tight and so hard at the moment that actually, my fear wouldn't necessarily be the regulator, although you need to keep an eye on them. The people who can make and break your business at the moment are the professional indemnity insurers. Because if you're not a good risk, and money laundering is a key risk, if you don't get that right, when it comes to renewal, they will either throw your premium through the roof so that actually you can't afford it, or they won't give you cover in the first place, whether you've been with them for 20 years or not. So there's, as I say, I don't like being a doom monger, but at the end of the day, if we don't appreciate these particular challenges that are out there and accept that they exist, then how can we move forward positively?
It would be remiss, and yes, you are a doom monger, Brian.
Thank you, David.
But it would be remiss not to mention that there are things happening, particularly around the digital ID space, that are going to enable greater reliance on a single source of truth. And there's some work being done in that space. Is that something you're familiar with?
Absolutely. Yeah. We've got there's open banking out there. There's digital identity. There's so many things. As I say, if you can call them benefits from the lockdown, a lot of people have now sort of really got on quickly to say, if we've got people working from home or now working in a hybrid environment, how do we serve our clients quickly, efficiently, get the information that we need, but to make sure that information is cast iron, or as cast iron as you can get it. And so, I think technology is the way forward. We've got to keep things simple, because I think one of the issues that people forget is, we can have all these technical systems out there, but if it's not simple, it can become a very, very big risk. So keep it simple, police it, enforce it. Again, I see lots of case management systems and other systems where you're supposed to put something in a box as part of the sort of the tracking, and people don't do it. Well, why isn't that being picked up? And I have to say, one of the big issues that I used to find was people didn't actually do the money laundering boxes. They didn't put in all the various things. I suspect that has changed to a degree now because we've moved away from paper a lot. And so people are very much thinking, well, I don't have to put it on the file, so I'll just put it in the system. So I'm hoping that that will be a positive thing. But yeah, technology comes with lots and lots of benefits, but if you don't train people on it and you don't police it and all those things, it can actually be a waste of money to start with. But it can be a very big risk. And you're wasting your time and energy really if you don't use it to its full effect.
That brings us to the end of today. It's been fantastic to have you on. Thank you so much for your insight. I think it's fair to say that anti-money laundering is and will continue to be a huge challenge, not just for conveyancers, but for the whole of the law firm. And I'm heartened to hear that you believe that technology is a solution, because it absolutely is. And law firms should be looking into how it could help their businesses.
Absolutely.
Thank you very much indeed for joining, Brian.
No problem. Thank you very much for the invitation, David.
Thank you to everybody for listening. You can hear the Today's Conveyancer podcast on your preferred podcast player and download it from Today's Conveyancer as well. That's all for this week. We'll catch you soon. Thank you.
You're listening to the Today's Conveyancer podcast, the leading source of information for residential property lawyers in England and Wales. Don't forget to subscribe and sign up to our free newsletter at todaysconveyancer.co.uk. You can also follow us on LinkedIn and Twitter.